Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. We talk to a lot of people who have been involved in trip and fall or slip and fall or other kinds of premises liability cases. Many people who've been involved in slip and fall or trip and fall cases are under the mistaken impression that just because they fell on somebody else's property or in a business, that their medical expenses are automatically going to be taken care of by the property owner. Well, this just simply isn't the law in the state of Florida. The only way that a property owner or landowner or business owner can be forced to pay the medical expenses for someone who's slipped and fallen or tripped and fallen in their store or on their property is if the plaintiff or the injured person, the pedestrian, can prove that the owner was somehow negligent. Many people are also surprised to learn that even if they prove a good case against the property owner or landowner, that a jury can still be asked to compare the negligence of the property owner or landowner to that of the pedestrian. So the injured pedestrian can still be blamed, potentially, for contributing to their own trip or slip and fall. The reason for this is a concept called comparative negligence. And under comparative negligence in Florida, a jury gets to look at the entire picture of any accident and decide the percentage of fault that's assigned to each person who supposedly caused the accident. In every slip and fall case I've ever handled, and I've been doing this now for about 27 years, there's always a component or a defense raised by the insurance companies or the defendants in these cases that the pedestrian was comparatively negligent. And the most simple way to talk about this defense is the defendant will always argue that the plaintiff wasn't watching what he or she was doing or wasn't looking out for their own safety. The argument is that even if there was something wrong with the floor or even if there was something slippery on the floor, that the plaintiff, if they had been watching what they were doing, if they had been paying close attention, would have still been able to avoid it and the fall never would have happened. Do you know why defendants raised this defense as their number one defense in every single slip and fall or trip and fall case? Because it works. It does. You can look it up. If you look up jury verdicts of slip and fall or trip and fall cases, you will see a bunch of them where the juries have placed the majority or all of the blame on the pedestrian for not watching what he or she was supposed to be doing or not watching out for their own safety. It's just such an unfortunate thing for pedestrians who've been seriously injured sometimes that this defense is readily available and people, the jurors, are willing to buy into it. Fortunately, after doing this for so long, we've been able to develop some strategies and techniques in these trip and fall and slip and fall cases that help us avoid or defeat or at least diminish the he or she should have been watching what they were doing defense and still make some really good recoveries for our clients. If you have any questions about this comparative negligence defense or the he or she should have been watching what they were doing defense, please reach out to us. We love to answer questions. All you have to do is call us at 407-254-4901. You can text us at 407-644-4444, or you can even reach us through the Facebook Messenger app.